Hey everybody, how's it going? I'm here today. We're going to talk about a really important issue for a change, right? But we're going to talk today about First Amendment law because, go figure, it's become pretty important. I don't know why, but it's become important in our country these days. And I thought it would be no better person to speak with than an expert on the matter. I'm going to be joined here today by my friend. I hope I'm not overstepping by calling him my friend, Ian Rosenberg. He is the author of The Fight for Free Speech, 10 Cases That Define the First Amendment Freedoms, and also this book here, the Free Speech Handbook. I got 2 copies because one's mine. I'm going to get it signed, hopefully, cross fingers. But he's also an adjunct associate professor at Brooklyn College, and he's a practicing media lawyer. But enough rambling for me. How you doing, Ian? Nice to meet you.
It's good to meet you. Thanks, Tom, for having me. Having me in my apartment, having me on your show.
No problem. Yeah. You're welcome for having you in your apartment here. First of all, great. Your books are great.
Thank you.
Congratulations. They're both very good. Just so you guys know, too, the book Free Speech Handbook, it's a graphic novel kind of format, so it's a little bit easier to digest and read, so you have no excuse. So you got to read it. But I thought we could start out with just putting everything into context. Why is the First Amendment protection against free speech here in this country so important?
Not surprisingly, as a free speech person, but I think free speech is fundamental not only to our Constitution, but to our democracy. You know, the marketplace of ideas underlies all of First Amendment law. And in Chapter 1, I talk about how that metaphor came about. And it's a really fascinating story of taking place in the 1920s, which is really the beginning of modern First Amendment law. And a group of anarchists, Molly Steimer is one of them, a young Jewish anarchist who fleeing Russian anti-Semitism and pogroms, comes to this country, becomes a garment worker here on the Lower East Side where I live. And she's really radicalized. And she puts out with some friends these anti-World War I leaflets, really anti-America's incursion into the fight in Russia because she defended Russia. And she throws these anti-World War I leaflets from buildings on the Lower East Side, literally throwing them from rooftops in English and in Yiddish, and people freak out. She is arrested, her compatriots arrested, they're a trial rife with anti-Semitism, and they are convicted for 10 to 20 years, and it goes up to the Supreme Court, and the convictions are all upheld for speaking out against the government, for speaking out against the draft. And in dissent, Justice Holmes, joined by his friend Justice Brandeis, creates this notion of the marketplace of ideas, which is essentially that the best test of truth is the power of an idea to get itself accepted in the marketplace. So using an economic model, I think, to sort of make it more palatable that he was trying to defend these radical anarchists. The concept is that the government has no place in intruding with people in their ability to hear and receive and express ideas. And so I think that is why our system works. And it's at the foundation of how our free press works, how our ability to interact with the government works. And I think it is really central to understanding when there are attacks on free speech, going back to how this sort of relates to the marketplace of ideas. I think it's always a really useful place to start.
And not just that it's important, but it's almost what makes the democracy work.
Yeah.
Like it's inherently, it's essential in the sense that, the marketplace of idea births the best idea. It makes things move forward in the best possible way.
There's another part of the less famous part of Holmes' speech is he says, that is the idea at any rate. It is an experiment as all life is an experiment. And I love that line because it's just both so poetic. But it also, I think sometimes people get hung up on but truth doesn't always prevail in the marketplace. Just like you don't always get the results you want when you conduct an experiment. You think you're curing something and then it doesn't work, or you want one thing to happen and another thing happens. So it's about truth, but it's also just, as you were saying, the system of our democracy. It's the worst of all possible systems, as Churchill said, except for the alternative. But it's also, I think, the best system, even with all its flaws.
Right, and this reminds me of there was a passage in the book by Professor Charles Lawrence, where you talk about it. Where he says we must eschew abstractions of First Amendment theory that proceed without attention to dysfunction in the marketplace of ideas from racism and unequalness of, I guess, representation in that marketplace.
Absolutely.
So it's got its issues as well that have to be acknowledged, but...
absolutely, and sort of who is let into the market. I mean, it used to be black people weren't let in the market, women weren't let in the market, and then, the whole marketplace notion as well, if you are rich, then you probably have a bigger megaphone, or you have 10 megaphones. I don't want to wholeheartedly say that there's nothing wrong with this model or that the system is perfect, But as I tell my students at Brooklyn College, even if you want to critique the model, or even if you think the system is totally failing, you'd still gain so much by understanding the model in order to critique it or change it.
And participate in it.
Participate
which is what we're all supposed to do.
Yes.
You start out your book pretty much with the Ben Franklin quote where they ask him, what is this Constitution? What kind of government is this Constitution going to give us? And he says, a republic if we can keep it.
Absolutely. And Justice Souter used to love that quote. And I actually took it from a speech he gave. And he says, with his sort of New Englandy accent, but you can't keep it in ignorance. One of the goals of this book, besides I think being sort of really entertaining and compelling stories of individuals who fought all the way up to the Supreme Court and won.
There's an elevator pitch right there.
Yeah, thank you.
Right.
The goal is for people to have a greater appreciation and understanding of their rights, not only so that they can express themselves, but so that they also can defend those rights when they're being threatened. Because I think people are often surprised about how much free speech protections we have in this country once you really start digging into it. And we need to know about those rights. Otherwise, they can be taken away without a sort of general awareness.
Yeah. Well, I guess that kind of leads us right into, let's get into the issues.
Sure.
I don't know if you have some kind of like telepathy or future predicting abilities, but your book pretty much nailed a few of the scenarios and things that we've kind of seen in present day.
Thanks, yeah.
In 2025, for those of you guys who are watching 10 years in the future, well, let's just talk about the issue now, is the Jimmy Kimmel thing that just happened today. Not today, this recently. And so Jimmy Kimmel is kind of nudged, let's say, off the air by statements made by FCC Chair Brendan Carr. He eventually gets pulled back. You had a case in there with Samantha Bee.
Yeah.
Where Samantha Bee says the C word, and I ain't talking about counselor. She says the C word, and there's a whole storm, and she was referring to someone in the Trump administration at the time, and I was hoping you could talk about that case a little bit, and maybe its parallels, and we can just go from there.
As you say, each chapter is about a key Supreme Court case, but I begin each chapter with a contemporary question. So as you're bringing up, the contemporary question in that is, can Samantha Bee curse on television? And then the story I tell is the Pacifica case, which involves a legendary comedian, George Carlin, and his seven dirty words monologue, which for those people who don't know is I won't say all the 7 dirty words, but you can watch it on YouTube after you watch this, and it's still amazing. And those that was on the radio, WBAI, a public radio station, and somebody who was actually an activist was listening with the intent to try and find something to complain about on this liberal public radio station. And he complains to the FCC. It goes up to the Supreme Court because the FCC sanctions the broadcast. And this is, most people don't know what the FCC really does, understandably. The Federal Communications Commission is supposed to manage broadcast radio and television, essentially, but not censor. So they can regulate in certain ways, but by statute and by tradition and by the First Amendment, they're not supposed to engage in censorship. However, when they fine the station, in this case, the case becomes Pacifica. It's the conglomerate that owned the radio station. It goes up to the Supreme Court. And this is, most of the time I'm talking about the rights we do have. In this case, the Supreme Court says that there is no right to curse on broadcast radio or television. And the broadcast part is important. I'll get to in a minute why. But basically, all of the rights to offend, all of the free speech rights are sort of put aside because they say that basically that television and radio are so pervasive, it's like being slapped in the face and then saying, oh, you could defend yourself afterwards. And they were very concerned that kids had access to television and radio in a way that they arguably didn't to bookstores or newspapers or movie theaters. And so the great restriction in my book, and perhaps one of the most important restrictions in First Amendment law, is that in this country, we are not allowed, the FCC can regulate away cursing basically from 6 a.m. to 10 p.m. So how can Samantha Bee do that? She can get away with it because she was on cable. But I think the way in which it relates to Kimmel is just, again, how much the Supreme Court has thought about comedy. You would not think of them, they're not generally particularly funny people, but they have thought a lot about the First Amendment implications of comedy. And in that case, they're saying they basically aren't looking at the comic aspects, and they're looking at the cursing aspects. And they are saying that the cursing aspects can be regulated. But a case that I also talk about in the book that I think is even more relevant to the Kimmel situation is called Hustler versus Falwell. And it's this crazy battle between Larry Flynt, the publisher of Hustler, and Jerry Falwell, the founder of the conservative Christian group, The Moral Majority, the political group. And Falwell has this, Flynt has this parody ad mocking Falwell in Hustler, which was riffing on a Campari ad that really existed at the time. People talk about their first times having Campari, but it sounds like the first time they're having sex. And they then create this fake ad in that style that says that Falwell's first time was drunk sex with his mother in an outhouse. And that's the parts I feel comfortable saying. There's actually even more gross parts to it. And it goes up to the Supreme Court, and no one other than the extraordinarily conservative Chief Justice William Rehnquist, sort of holding his nose, says that even this satire has to be protected, because without it, we would have no political cartoons. He's very concerned about political cartoons being protected. And he says that if outrageousness was the standard, which is what had been proposed basically by Falwell's lawyers, if outrageousness was the standard, then all that would mean is that disfavored minority groups or disfavored opinion, dissident opinion, would ended up over and over again being regulated away, and that there could be no way to draw the line. So in both of these cases, in both the Pacifica case and the Falwell case, the Supreme Court looks at speech. On the one hand, they don't protect cursing, but on the other hand, they say that even sort of disgusting parody is protected, because without it, we would have no ability to gauge in political dissent. And that is exactly what Kimmel was doing. He was not doing anything disgusting. He was engaging in political dissent.
Yeah, and I thought it was funny that in the book you talk about the fallout, I guess, from the Falwell Hustler, and they became friends eventually.
They became friends.
Isn't that a beautiful story? Falwell and Larry Flynt became friends, an unlikely duo, like the little duck that goes around with a cat, the funny furry friends. But yeah, they became friends eventually.
Both of them are very flawed people, but it is a strange testament to the power of the First Amendment that they could find a common ground even with having such radically disparate views.
Yeah, there's hope. There's hope for everyone. Huh?
There's even better examples, I think, of hope, but yes. But,
of course. We got to look for Larry Flynt for hope.
Yeah.
Well, to add on to this, I thought there was another case that we could tack on and talk about regarding, I guess, the point of view and criticism was the Sullivan case. Yeah. Where basically they put an ad in New York Times to celebrate civil rights activists. And in the process, they talk about, victories in Alabama, and there were, I guess, officials in Alabama who took issue with this because they felt like it was attacking them, so they sue. And then another one sues, and then the New York Times is kind of on their, against in the corner, they're in the back, their backs against the wall, kind of. It shows not only the question of the viewpoint, like you're putting forth a viewpoint, all that, and you're getting kind of punished for it. There's lawsuits. They're getting sued, and they have to win them, or they're going to go under, that kind of thing. So I thought we could talk about this because this is also relevant today, because a lot of people are being persecuted for their choice of side that they're picking or their perspective.
Absolutely. Yeah. So just a little bit more about Sullivan. So exactly as you said, there's this pro-civil rights, pro Dr. King advertisement and pro the student activists who were engaging in sit-ins at the time. And the Southern police authorities, this guy, L.B. Sullivan, basically like a police commissioner, he decides that he is going to get back at the New York Times. I mean, it turns out almost nobody read the article where he was, and nobody really thought it actually criticized him. He ran on a segregationist platform, so even if he was being criticized as anti-civil rights, that's how he got elected. But nonetheless, he sues the Times for libel. And because the ad had small inaccuracies, the number of times King was arrested, whether this door with student activists was padlocked, or they were just told that they had to leave. There were some flaws in the ad, and the standard then for libel was the statement false, and was reputation injured? And that was basically it. And technically these were false, and he sort of argued that because it was critical of him, his reputation was injured, and it was a very weak point there. But it goes up to the Supreme Court, and up until that time, the First Amendment really had no role to play in libel. And the court realizes, as you said, the Times was basically going to be bankrupted by these lawsuits from people in the South. And one, that's bad, I think, for the press if the Times goes under. But even more importantly, all of the nation press and news organizations were looking to this and had actually pulled out of having reporters in the South to cover the civil rights movement because they were afraid of lawsuits. So not only were they economically in trouble, but the whole coverage of the civil rights movement, which was designed intentionally by Dr. King and Andrew Young and others to gain white sympathy in the North by timing their protests to get on the news or to make deadlines for the newspapers, that was all up for grabs. And the court basically creates, Justice Brennan creates a new standard in Sullivan that says that you can only be, the public figures that sort of evolved, but basically public figures can only be criticized, not only if there's a false statement, but if there is a knowing falsity or reckless disregard for the truth. So what knowing falsity means is lying. Essentially, like an intentional lie. And so that's hard to come by, but also reckless disregard to the truth. I always sort of do this like sort of gesture of like, somebody says
it's like a dabbing.
Not dabbing, but sort of, I don't even want to see it, no, I don't want to see that you say you were out of town when I'm accusing you of murder. Right. No, I don't want to see the document that proves that you had the right to that transaction. So this standard, which is the bedrock of sort of, press law today, really means that the press can't lie and get away with it. So when the Trump says that the press is protected by lying, that's just absolutely false. Intentional lies are not protected at all. But small mistakes are when you're talking about public figures.
And the name of this is actual malice, right?
Actual malice.
Actual malice is the name of the standard. Yeah, sure.
It is called actual malice, but basically knowing lies or a refusal to investigate the truth is what the standard of actual malice is. So people see that term thrown around all the time. And, when Trump is currently suing the New York Times for $15 billion and suing the conservative Wall Street Journal over their Epstein reporting about him, alleging that he sent Epstein a birthday card. He's suing them for $10 billion and his sometimes buddy Rupert Murdoch. On the one hand, these news organizations are absolutely going to be protected under the actual malice standard. Mm-hmm. But on the other hand, the pressure and the financial impact of these lawsuits is part of an intentional practice to try and destabilize the mainstream media.
Yeah, and I think this is an interesting time to get into this idea of intimidation and implied threats. Mm-hmm. Because what you just mentioned, Trump suing directly. I'm going to sue you directly. It's a pretty open and shut case, and a little more open and shut, let's say, in those cases. And then let's say we go back to Jimmy Kimmel, where it's a statement, a very vague, subtle threat from the FCC chair in a moment where his parent company is dealing with certain issues that the FCC has jurisdiction over that they can basically screw them on if they don't want to, if they don't want them to, if they don't want to see it their way or whatever. So it's this kind of environment that gets created where people feel the threat. They don't necessarily see it. You can't point to it. I was hoping you could talk to that because some of the cases do deal more with direct threats, direct lawsuits, direct infringements or whatever. And some of the things we're seeing today aren't that.
Right. Well, I think that adds an extra layer of complication because the goal, I think the intentional goal is to make things both vague so that they can take it back later or so that there can be some kind of deniability, but still creates a chilling environment. There's a term that First Amendment lawyers and scholars use all the time, sort of the chilling effect. Yeah. And that's the idea that maybe this law that's being passed, it wouldn't directly affect you, or maybe you would win on some kind of appeal under First Amendment grounds, or maybe it's only, it seems like it's all of these people, but it's only these people. Right. But nevertheless, everyone's speech ends up being chilled because people are afraid of lawsuits and people are afraid of going to jail or what have you. So you can create a chilling effect almost more effectively, which is one of the new things the Trump administration, I think, has sort of I don't want to say brilliantly, but very cleverly sort of developed, you can create a real climate and fear of the ability to speak your mind, even if you are not actually litigating against people. So it's creating this culture of fear and this culture where people are not willing to express their views, perhaps on many different topics, but certainly on topics that involve criticizing the president or criticizing the administration or criticizing people that the president and the administration support. So I think that's very, very dangerous. You know, Timothy Snyder, we were talking about this before, that the Yale historian who wrote the amazing book on tyranny during the first Trump administration, you know, has a line that you should not obey in advance. That the way to fight against authoritarianism and what autocrats expect is that people will give in before they're actually sent to jail or criminalized or sued or what have you. And I think we keep seeing corporate America over and over again obey in advance. And during the 1960s protests in Paris, there was an expression that says, to give in a little is to capitulate a lot. And I think we keep seeing these, well, it's just Jimmy Kimmel. Well, it's just Stephen Colbert. Well, it's just people who were foreign students who were commenting against the war in Israel or whatever. They're not thinking about them, but it's the entire climate that is really being affected by this approach. Now, we can get into why I actually think the Carr statements were pretty explicit. And maybe one sidebar about why, whether it's an explicit threat or a direct explicit or an implicit threat matters in constitutional law, is because sort of one of the fundamental concepts of First Amendment law is that you need government action. You need what's called state action. As you know, the First Amendment begins, Congress shall make no law abridging the freedom of speech or of the press. Congress has been expanded through interpretations of the 14th Amendment to mean Congress or state actors or basically police, teachers at public schools, other administrators, government officials, but you need some kind of state action, because without that, I talked about the Colin Kaepernick case and him taking a knee. With the NFL, private employers aren't the state, and so private employers basically don't have to pay any attention to the First Amendment. They might be violating First Amendment values. I think they were outrageously, but there's not actual constitutional remedy. And so that's the other thing that they're trying to do here, is they're trying to get around state action so that there won't be a litigation response.
Cool. So to leapfrog on you, where you were saying, I think it is important to note that companies don't have the same obligations when it comes to free speech. They can fire you. They can see things. You had cases in there where a company can, where companies can fire you for, let's say, doing something they don't like or whatever on your social media, things like that.
Julie Briskman flips the bird at the president and now an elected official, but then was fired from her company.
For posting a picture and posting a little thing about her, they took pictures, a photographer had taken a picture of her flipping the bird as Trump's motorcade was going by. And she thought it was funny and, let me post it. And she got fired. So
actually, she didn't even post it.
She didn't even post it. She reposted it, right?
She reposted it. It was Agnes Press, I think, because there was Trump's motorcade had all of the photographers behind them, so they got an amazing shot of her.
Yeah, it is important. You mentioned Colin Kaepernick. So he takes a knee. He gets, arguably, I guess, allegedly gets, frozen out of playing again in the NFL. There's been settlements since and all that, but it's still important to do those things. And so in his case, I thought it was a good part of the book where you kind of put it into perspective, the effect that had, even if he lost his, one of them was he inspired people to do those things in settings where they are protected.
That's right.
So, for example, you are protected at a public school. In high school kids, if they took a knee or whatever, they can't be expelled or things like that. It also kind of provides guidance in the sense of what we can do to protest and be patriotic in certain times and whatnot. And I was hoping you could talk to that, because there is this kind of split between what you can do in companies and corporations and work and in government and public school, et cetera.
Well, exactly as you say. So going back to this requirement for state action that we have, so the NFL is a private company, but if you are a student athlete, and Kaepernick inspired not only student athletes, but athletes all over the world, but if you are a student athlete at a public school, because again, private schools are like private companies, you're essentially buying a transaction, and so therefore of education, and therefore they can do what they will. But in a public school, if you took a knee, you could not be punished basically for viewpoint discrimination in any way that was different than somebody who would be doing something similar without the political message. So you can't walk out of school necessarily and not get a detention because you're not allowed to walk out of school. But if you're being punished more for walking out of school because you're going to a Black Lives Matter protest, that is absolutely protected. And I think, you brought up some of the most important ways in which Kaepernick has influenced people. And I do think Kaepernick's Take a Knee movement is probably the seminal and most important protest movement of our modern times. But I use it in the book to go back to the story of Jehovah's Witnesses, who during the beginning and then during World War II refused to pledge allegiance to the flag at a time when that was considered really a shocking act of defiance. They felt it interfered with their religious beliefs about idolatry to pledge to an idol of the flag. When the case goes up to the Supreme Court, the court basically determines that there is a right not to speak. This is sort of separate from the criminal idea of like you have the right to remain silent. But our speech rights encompass the ability to not let the government put a message in our mouth that we don't want to have there, or to force us to speak a message that we don't agree with. Although, again, Kaepernick, as a private employee, does not have that right. He represents the right that all Americans have in connection with their government, in connection with their schools, in connection with state actors, that you cannot be forced to express a message you don't believe in. And I think we often talk about speech from the perspective of, I want to say this, and I should have a right to say that. But part of it is also the idea that we can't be forced to say something that we don't agree with by the government.
Yeah, I mean you're getting into like George Orwell territory when you're forced to say something, or salute to the dear leader or something every day. So yeah, it's very important, and I think it's important to note as well, and to emphasize that even at those times. So you were saying the Pledge of Allegiance during World War II. That's blasphemy to fight against that. Even going towards like civil rights, you talked about having the armband, for example.
Mary Beth Tinker.
Yeah, Mary Beth Tinker, who had the armband in her school. She got in trouble for that as well. And not only were these actions viewed unfavorably by the population at large, the civil rights movement wasn't necessarily looked at as a positive thing. Even people like Martin Luther King Jr., who has his own holiday now and all this stuff, back then was not a popular figure. And so people have to realize that kind of comes with the territory of fighting for free speech, of fighting, against powers that be or whatever, is this idea of mainstream unpopularity.
Absolutely. And I think when the Kaepernick situation, I try and use that as a way to bring up these points that you're just raising, because people so often would say to Kaepernick, well, I'm in favor of protest, but you're doing it disrespectfully. Well, that was why he was sitting down, and then he took a knee because he was told that was more respectful by military figures. So there's this well, I'm in favor of speech, but this speech is wrong. I mean, and as you bring up, it's important to remember how unpopular dissent is at the time it happens. Now we can sort of look back with a sort of rosy glow of inevitability. Yeah. Oh, the civil rights movement, of course, was a vital corrective to segregation. Oh, Molly Steimer and her anarchist friends are sort of charming in their, in their anti-government feelings, and like now they're free speech heroes in some way. But these people were all generally reviled. Even Dr. King was unpopular. Even the March on Washington. I have the exact Gallup quotes in the book, but the March on Washington was considered basically too much by essentially white mainstream America. And so we always, I think, need to look at protests or expressions that we don't agree with a sort of awareness of how it is not. Most protests don't come from people who are heroes. Most protests come generally from people on the out, not that they shouldn't be heroes, but are perceived as being heroes. Most protests come from people outside of the mainstream. So what's so shocking about Kimmel or Stephen Colbert being taken down is they are so popular, and they are so, at least with much of the country. So they're rare examples of really popular people speaking dissent. But most of the time you're hearing it from people who are marginalized in some way and who may not be trying to convince people, but just trying to express their deeply held beliefs. And I think it's very important to remember the point you're bringing up, that when we look at these protest movements, we need to realize that we might not like them today or tomorrow or whenever, but that doesn't mean that they're not protected, and that doesn't mean that they're not directly in line with people who spoke out in the past whose rights were similarly protected.
And this also goes to the idea of the marketplace of ideas. You want to have all these ideas in a certain place and let those kind of play out. There was another case, go figure, you had another case that applies this, and it goes to the Phelps case, the Snyder-Phelps case. Yeah. And this is the Westboro Baptist Church. I don't know if you guys remember them. I don't know if you guys love the aughts or whatever, but Westboro Baptist Church, they were the ones who protested at soldiers' funerals during the Afghanistan and Iraq conflicts, and they would put up these brutally awful, horrific, posters. They were right near the hearses and all that stuff during these funerals. And that case went to the Supreme Court. Obviously no one would disagree that those are horrible things to do as a tiny little church, that they were the only ones who really are like, no, we have a right to say this. And the court found in favor of them. The court said, it doesn't matter if you don't like what they're saying. We can't strike this down, because then that means the other side too. You can strike other stuff down that might not be agreeable. Who's to decide what's agreeable and all that stuff? So I was hoping you could talk about that.
Yes. Well, so you set up the case beautifully. Yeah. So the family of a person who was killed in Iraq sues the Westboro Baptist Church, gets a multi-million-dollar settlement. The church, was like, thinks it's hilarious and had these parody songs and sort of danced their way up to the Supreme Court, reveling in the publicity. And the court reaffirms something that most people don't realize, which is that hate speech is protected. And that even by the conservative court, Chief Justice Roberts, who considers himself one of the foremost defenders of the First Amendment, I think he's slightly self-aggrandizing about how much of a defender he is. But what's interesting about the First Amendment is that you have sort of strange bedfellows. You have conservatives and liberals who, both on the court and in politics, who are big advocates of it. And he basically says, hateful as that message may be, as terrible as the way they did it was, they were still also respecting the bounds of the law. They were on the public sidewalk. They were not blocking the funeral. And he basically says, we can't punish the messenger for messages that we don't like. Right. And so a lot of times you'll hear people say, well, I'm in favor of free speech, but I'm not in favor of hate speech. And usually when people are talking about hate speech, the legal terminology is either something like the Westboro Baptist Church, where they had slurs on their signs that I won't repeat, or racial or other types of slurs. It usually means hateful words about a group. And that is protected. Snyder is the reaffirming that that kind of speech is protected, because if we start letting the government choose whose hate speech we can silence and whose we don't, that's a very troubling place to be. And we just saw this happen. Attorney General Pam Bondi said that after Charlie Kirk's murder, that we're going to go after hate speech, and then the next misusing the term. And then the next day, or very shortly after that, President Trump tells John Karl, the White House correspondent for ABC News, we're going to maybe go after you next, John, because I know you have a lot of hate in your heart for me. His question for him was, what do you think about what Pam Bondi just said, Attorney General Pam Bondi just said? Not an aggressive or offensive question, even though that should be protected too. And so transparently, the Trump administration has made clear that what they mean is hate speech is anyone that disagrees with them. Bondi's remarks got rare sort of Republican pushback, also weirdly from Brendan Carr a few days before he then criticized and implied that Disney should take action against Kimmel. But all of this is just to say that even if the current administration's view of hate speech was correct, and they're misunderstanding the term, but that hate speech also is protected. And so often, I think liberals had a lot of discomfort with that. A lot of it understandable. It means that terrible things can be said to groups of people, and that can really wound people. But we don't need to diminish the pain and impact of hate speech before even getting into hate crimes. But I think that some people who on the left were maybe very conflicted about hate speech, and it's the hardest sort of thing to get emotionally okay with, I think, in the book and in constitutional First Amendment law. But I think that those people are maybe having a different view when you see like, oh, but what if you have an administration that defines hate speech as anything that disagrees with them? This is why all speech of that kind of nature, all viewpoints of any kind, even espousing those kind of things we hate, need to be protected. That's the Supreme Court's view, and I think it's right in that regard.
Okay, so we've talked a little bit about how companies can they're free to, I guess, censor their employees in certain ways. They don't have to abide by free speech protections and things like that. What would you make of the idea of cancel culture and what a lot of people consider the woke ideology and being canceled for not being woke, and this self-censorship that a lot of people believe is happening?
I have complicated feelings about that. So first of all, it's not a term I love, even though you have to use it because that's what everyone uses, because it doesn't actually have any sort of legal meaning. Right. In general, and I think it's a great irony that we are now living through an administration that began by saying Trump said that, I've had this executive order that we're going to restore free speech in America, sort of alluding to this view that liberal America and liberal universities are creating this woke environment in which people don't have free expression, which I largely disagree with, but I mean, disagree with that perception. But if that was true, all of a sudden, Republicans are that support Trump are turning into snowflakes. They can't handle a joke from a comedian. Right. I mean, that seems to me the ultimate sensitivity that we were told for so long by conservative voices, that we all have to just sort of toughen up and take it. So I think that where the sort of legal elements of this come into play is that, one, a reminder again to people that you need state action. So to have a constitutional legal issue. So if people are being canceled, but not by the government, that's not censorship. That's not a constitutional violation. That might be a philosophy that you can disagree with, but it's not a violation of the First Amendment. And I would just sort of add to that point, people often think that when you express views, that your First Amendment rights means that not only do you get to express your views, but that you are free from consequences. And I like to say that free speech doesn't mean being free of consequences. Because one, if you express your views and people say, I dislike that view, I think that view is terrible, I'm not going to buy your book, watch your movie, join your gym, hire you. Yeah. That's the price we pay. That's I would argue part of the marketplace of ideas. One person shouting one thing, another person shouting back at them, I don't like that, and now I'm not going to buy your pickles. So I think people sort of forget that, in fact, you might have a free speech right to do something, but that doesn't mean you have a free speech right to get off sort of with any consequences or with any ramifications. Right. So often in the book, there are examples of people who arguably have a free speech right to do something, and yet have to suffer significant consequences. The students who won in the Jehovah's Witness cases that we talk about were out of school and had to be sent to schools way away from where they lived and faced terrible persecution. Even in the championing of free press in the Pentagon Papers case, a majority of the court agreed that the New York Times should be allowed to publish it. But also a majority of that court separately had basically said that the Times could have been criminally prosecuted, not just Ellsberg, who leaked the documents, but that the Times themselves, the publisher of the New York Times, could go to jail for publishing these documents. You just can't stop the press from publishing them. Right. So even in our sort of greatest First Amendment victories, we are not immune for the ramifications of our speech. And I think that's generally a good thing. I think we should, you don't want a culture in which people are afraid to speak, but also in sort of the opposite of that, you don't want a culture in which anything you say is sort of free from consequence.
Right. And it seems like what you were saying before, that the term woke has become kind of just basically this pretense to pursue speech you don't like. You know, as you were saying, seems to be a double standard wherever. That's it. Like, use woke for stuff that we don't agree with, and you can just use that freely. There's no real definition. It's nebulous.
Yeah.
And we'll do the same thing where we're, you know, as you said, snowflakes or whatever, but it's just because we're not on that side that it's not woke or whatever.
Yes. I mean, I think those are terms that are clearly showing people's political biases. And it was, you know, prior to the second Trump administration, people were certainly making that argument. But like, what if you wanted to have, people critiquing you? You know, that sort of fell on deaf ears. But now we see that with the Trump administration's attack on universities basically aggressive, I would say unconstitutional efforts to remove funding from universities with the pretense of fighting anti-Semitism, but I think really just trying to attack institutions that have historically been liberal or historically opposed Trump. You see that sort of pretense of academic integrity is pretty transparent, and that really so much of these attacks are about power.
Yeah, no, of course. And as far as the cancel culture and everything with regards to speech and, for example, comedians, you know, I guess like 5, 6, 7 years ago, that was the thing. Oh, cancel culture is killing comedy woke, and those people who complain are now the richest comedians in the country. Yeah. Go figure. But I wanted to touch on that as well, though, is the universities. And that right now is a hotbed for free speech discussion. Yeah. You know, you have university presidents feeling the pressure to step down. Yeah. They're being attacked publicly, explicitly from members of Congress, the President of the United States. And I was wondering what your take is on that, because the government does hold levers for colleges, the funding and these different things. Where's the kind of the ability to resist this kind of censorship, really?
Yes, I do think it's censorship, and a lot of what I'm trying to do in the books is say, look, here are 10 really clear cases that really clearly define what our rights are. This is pretty complicated, so this isn't super clear. But I think that in a big overview terms, although the government can condition certain grants, they can factor in things. So the big cases like the NEA cases of the 80s, when Karen Finley and Robert Mapplethorpe and other artists had lost their NEA grants because they were doing radical art that was pro-gay or feminist or just sort of outrageous, like Andre Serrano and his Piss Christ photo. The Supreme Court basically said that taste can be factored in when you're offering a grant, but so there is I just want to put that out, that there is an element to people being able to sort of condition funding on what they want. However, there's a bigger free speech principle that the government cannot engage in what is called viewpoint discrimination. And viewpoint discrimination is basically the government can set limits on things. They can set time, place, and manner restrictions. If they're giving a specific grant, they can factor in certain things. But the government can't say, we're going to let people who have Democratic views lose their funding, and people who have Republican views gain their funding. They can't say Black Lives Matter people can never get a grant, but Young Republicans or Federalist Society can get a grant. They could say no grants to political organizations. That wouldn't be viewpoint. That would be sort of a content neutral rule. But what I think the Trump administration is pretty transparently doing is engaging in viewpoint discrimination with these universities and unconstitutionally removing, funding for cancer studies, which have nothing to do with anti-Semitism. They have nothing to do with campus culture. They have nothing to do with whether or not students or faculty are engaging in protests about Gaza or what have you. And I think, what is the pushback? Ultimately, I think that those are difficult cases to win, but I think that the universities would win those cases. What is so troubling is that universities like Columbia have decided not to fight. And once again, they are obeying in advance. I mean, there has been an action taken, but the funding wasn't removed. The funding was being threatened from being removed.
Yeah.
And, what are these bastions of not only prestige and higher learning, but also these corporations that have vast endowments, that have billion-dollar endowments, which they've always said that they can't afford to give people free tuition because they have to keep these giant endowments for emergencies. Okay, this is the emergency that these endowments are for. This is non-legal, but I think that, Kimmel and Colbert and others have said correctly, I think, that you don't solve the problem of a bully by giving them your lunch money. And what these universities, I think, misguidedly have thought that if they just capitulate to Trump, that these problems will go away and they'll get their funding back when the publicity dies down. And I think it's been a terrible political move. I think it's been a terrible move in terms of what they stand for in free speech. Columbia used to have a president who's one of the Lee Bollinger is one of the country's foremost First Amendment scholars. The idea that university would so explicitly cave on restrictions of their students and their faculty, I think is tremendously worrying.
To compare it, you brought up the fact that they're like corporations in themselves. I mean, at the end of the day, a corporation, and not to say that they're directly corporation, but use corporation as an example, they're really just worried about their share prices, their stock prices. Right. So in a way, it's almost like their hands are tied. And a part of that may be a result from, let's say, the cutting of federal funding for universities over the past however many decades, just been cut and cut. They're relying on their tuition, they're relying on their endowments, they're relying on the corporation side of their business. However, because they respond to the people's, opinion, and I thought this was another interesting part of the book, there was a great quote where it says the life of the law has not been logic, it has been experience. And I think Holmes, that's right. And so what that kind of, to me, it meant was that the way we interact, the way our opinions change, the way our, discourse affects the people above us, whether it is the companies, like you brought up Kimmel earlier and how Disney eventually brought him back, and even colleges and whatever who maybe disconnected from the levers of the federal government, but they still are going to have to listen at some point if the scale tips enough.
Yes, and I think
was that too roundabout? Should I do that over again?
I mean, I thought it was good.
Thanks.
But what I just want to make one little distinction that I think that universities do have endowments like giant corporations. But I think, unlike, as you correctly point out, that corporations are basically just bottom line driven or shareholder price driven or whatever, that universities actually have built into their charters, built into their missions, they have an obligation to stand for free speech principles, to stand for dialogue, to stand for communication. And so I think that they are betraying their missions and their students when they, again, are capitulating. But going to the corporate side, one of the few glimmers of hope in the First Amendment world right now is what happened after Kimmel was indefinitely suspended, which certainly sounded like he was permanently fired. And that was the buzz. Not only did the creative community sort of rally behind him, but much more importantly, by people in the viewing community saying, I'm going to cancel Disney Plus, I'm going to cancel Hulu, I'm going to keep talking about this issue so that it doesn't just get rolled up in the blitzkrieg of other First Amendment and other outrages that are happening by this administration. It was really a people-powered defense of Kimmel that saved the day for him. And much more importantly than, as Kimmel himself said, this show is not important. What's important is that we live in a country that can have a show like this. But what's more important is that we are saying as a society that our right to hear these views, our right to receive contrasting information, dissident information, comedians who are attacking the president in humor or just, with vitriol. Either way, that's part of our free speech rights too. That's part of our ability to receive information and hear what's going on. So it's really our free speech rights that are being defended, not just Kimmel's.
Yeah, there's a little snap stare. That's a good time for that. I thought it'd be interesting also to talk about, real quick, this idea that people bring up a lot of times to attack free speech, in their minds justifiably, and the famous scenario, the hypothetical, Brian, you think you know where I'm going.
Yes, I do. It's my Biet noir, my bugaboo about things I can't stand. Yeah.
Well, then I'll just go ahead and say it out loud and watch the hair on your arm stand up is the fire in a crowded movie theater.
Yeah.
You can't just go around saying everything because, there are things that you can say that have an effect or whatever and can be dangerous. And Oliver Wendell Holmes was who brought the example of going into a crowded movie theater and yelling fire. People are could possibly get hurt. It's a whole thing. You could create a big problem. So in that case, it would be okay to go ahead and regulate that right off the bat. And I was hoping you could talk to that point because that is something that is very commonly misunderstood, misquoted, etc.
Misquoted. And it drives me bonkers. And I just talked about it in my class last night to my students. So the quote that people always, as you say, people always say, well, I'm all for free speech, but you can't cry fire in a crowded theater. And then they say, and that's why you should censor this book. Right. That's why you should restrict the speaker. But what Holmes really said is that you can't, in a case called Schenck, you can't falsely cry fire in a crowded theater and cause a panic. And what's crucial about that is that if we are going to restrict speech, that the two first step necessary components of thinking about restricting speech are falsity and harm. Because if you cry fire in a theater and there's a fire, you're a hero. You're saving people's lives. And if you're crying fire in a crowded theater and somebody, the stage manager, steps up and goes, it's dry ice, don't worry, people, everyone sit back down, then there's no harm. But falsely crying fire in a crowded theater and causing a panic is the threshold of when we can consider to restrict speech. And Holmes goes on in other cases to say that that's not enough. It's what the sort of, LSAT question is of a necessary but not sufficient condition, meaning that if we want to restrict speech, we should never do it unless there's falsity and harm. But even then, that doesn't mean we get to restrict all speech that's false or harmful. Hate speech is false and harmful, but it's protected. But I do think it goes to a fundamental misunderstanding about what is protected in this country. Actually, even false and harmful speech can't be protected. That's just the beginning of when we could consider to restrict speech.
Right. Well, now you have that. You can go to your cocktail parties and, tell people to ask you about that and, show off your knowledge. But what would you say is an example of somewhere where you do think it would be okay to restrict speech?
Well, we restrict. So, I'm not a free speech absolutist, and the idea of free speech absolutism is pretty much a red herring. But we restrict speech in all different kinds of ways. We restrict, and I'm totally fine with it. We restrict speech in fraud. If you're tricking someone in a business deal, that's often speech or written speech. That's okay. Sexual harassment is almost always speech related. I mean, and physicality, but usually like sleep with me or you'll be fired. That's not protected. Perjury is not protected. And child pornography is not protected. And advocacy of illegal action in the Brandenburg test is key when it's imminent harm that is intended to cause harm and is likely to cause harm. So even illegal action, advocating illegal action is largely protected, but not let's all go kill that guy right there. We're a crowd, get that guy. Right. That's not protected, nor should it be. So there are limits to speech, but we have greater free speech protections even today in this country than any other country in the world. Even liberal democracies, even Europe, Africa, but these are not limitless rights. And so part of the book is to both, goal of the book is to both sort of explain and celebrate the rights that we do have, but also try and make clear what the limits are. State action is a requirement. There are limits to advocacy of illegal action. There's a limit to what you can curse on broadcast radio and television. And it's important to know that those limits. And I think too often people sort of say, well, the problem with free speech in America is everything is permitted. And that's just not what the law really is.
To kind of wrap this up, everyone's kind of freaking out, obviously, with a lot of this stuff. So it's good to give some kind of actions people can take or some kind of way people can be a little more proactive. And in the book, at the end, you kind of wrap it up saying that there are a few things that you can do. You talk about protecting dissent, defending the press, resisting government speech regulations, expanding the marketplace of ideas, and allowing speakers to express messages how they choose. With these kind of concepts, how do we make these more concrete? How do you protect dissent? How do you defend the press or expand the marketplace of ideas on a day-to-day, more practical level?
Right. Well, so I use, as you were saying, I use the Supreme Court cases as a way of showing what the law is very clearly and sort of how the justices are sort of defining the meaning of America. But free speech actions and free speech restrictions happen all the time in our world. And I think people are becoming increasingly aware of how often this happens in our everyday worlds, which will never get to the Supreme Court, no matter how likely you would be to win there or not. So it's happening in our classrooms. It's happening in our school boards meetings, certainly with efforts to restrict books from classrooms. It's happening in our churches and our synagogues and our mosques. It's happening at community board meetings. I know in one of your tours, you talk about how important it is to get involved in local politics. And I really want people to look at their free speech rights as a way of engaging with grassroots defense or advocacy for change if they don't agree with the way that our rights are protected currently. Every day, by knowing what the law really is, you can both sort of defend the restrictions that might be try to be imposed on you, or even better, restrictions being imposed on others. You can join their defense. Most importantly, you can hopefully have a dialogue about it, a dialogue that doesn't resort to sort of cliches about fire in a crowded theater, but instead talks about what our real rights are and why they matter. Those are free speech issues. And I think that the more people can be engaged with those kind of issues, it does have an impact. It has an impact on the local level, but it also can have an impact on the national level, like with Kimmel. When we know what our rights are, when we advocate for our rights, and when we advocate for the rights of others, the speech rights of others, I think that's when we're really serving the true meaning of the First Amendment. And I think, participating in our democracy in a more full and robust way.
Yeah, and to that point, I always like to say that I think democracy trickles up, and a lot of these cases kind of demonstrate that. I mean, Mary Beth Tinker wearing an armband, protest movements, Cohen in his case wearing a vest that said "F the draft," these kinds of things. And not to say you have to go out and do that, but protest movements. You mentioned the Women's March in your book. Like, these participating in these things has an effect, because you never know. These issues get hashed out from a local level. They go up and then they move to the Supreme Court. And not to mention people who fund these things, participate in these groups, defend these people, like you said, donate to their causes. All these things at the local level kind of trickle up. Well, there's also, you mentioned in the book, how the Constitution itself, it says we the people, right? It's not, the Constitution didn't do these. The Constitution, gave the format for us to then push for different rights. Slavery wasn't ended by the Constitution. All the civil rights, all these things came about because people pushed in those directions. So.
Well, and I think that's also looking for glimmers of hope. I mean, I think on the one hand,
I'm trying.
Can't
blame me for trying.
Let's hold on to some hope here.
Please.
On the one hand, you highlight that the people who bring these cases to the Supreme Court, and sometimes it's the New York Times or the president, but most of the time, most of the cases in the book are average, everyday people, school children, people, often young people, sometimes people who are not heroic, like the Westboro Baptist Church, but individuals, that they are the ones whose individual small cases are leading to our greater rights. And on the one hand, that makes our rights sort of us aware of how fragile our rights are, that they were not inevitable. They're not all explicitly laid out in the First Amendment. They're not all explicitly laid out in the Constitution. So that can be both scary, but it can also, I hope, be inspiring, that you never know when your sort of small act of courage, Mary Beth Tinker talks about her small act of courage to wear the armband, and then when the principal told her she was going to be expelled, she took it off. And she later then fought all the way up with her family. But small acts of courage not only create our First Amendment rights, but they can make a huge difference. Small acts of courage, small acts of speaking your mind, and then being willing to take the consequences for those actions can change the world.
And protecting other people's abilities to do that as well, because it's not always pretty. I mean, I thought it was interesting. The ACLU was the group that defended the Phelps. They're the ones who came in and defended the Westboro Baptist Church. The ACLU, you think it's a very liberal organization. They're defending people's rights to say these horrendous things because it's not about the content of the speech, it's the ability to say the thing.
That's right.
It's about protecting people's rights to say it. So, and especially in such a polarized society like we have today, that's an important thing to keep in mind. Because these things are being attacked, and if you're on the side that tends to benefit from, whatever, you don't necessarily agree with the comedian who's being, pulled off the air, you're kind of happy and you celebrate it, but you don't realize that that's actually hurting all of us. So, Sorry, I got on a little soapbox there. I'm sorry.
I agree.
Yeah, good. Good. Look at that. With the freedom of speech, freedom to agree here. Look at that. But you know what? That's great. I think that's a good note to end on. A little hope, huh? A little hope-starved world. But I guess just to round it out, I brought my own copy of your book here. I was hoping you could give me a little autograph.
I would love to.
A little John Hancock.
Indeed. I would be honored. Thank Tom for having me on the show.
No,
Thanks
of course. Thank you for
talk
coming.
about free speech.
And yeah, you guys should definitely check out Ian's book, Free Speech Handbook, if you want more pictures and color and all that. But you also have the fight for free speech, which is the actual cases, and they're both very accessible, obviously. But they're great books. Congratulations.
Thank you.
And I don't know. Thank you for having us here in your lovely home.
My pleasure. Thanks again.
All right. Thanks again. See you guys later.